Well, hello, everybody, and welcome to American Politics Legal Den. Of course, today we have some very exciting guests and our host, which is Bill Trezevatt. Bill, you're going to be, how I say, leading the parade and with our guests that are going to be on today. And of course, we have a very special guest, a person who is a constitutional scholar, which is not me, and a person who actually was one of the two people, as you all know, to get inducted before the U.S. Supreme Court. You need somebody who's been licensed before the Supreme Court. And this person actually was the one who signed me into the Supreme Court of the United States, believe it or not, Bill, a long time ago. Yeah, so I've known Jeff a long time. Jeff is an attorney. He is a former candidate for a court of appeals. He actually practices law and does and is basically a constitutional law scholar. So I think to bring him on to answer these questions as opposed to me is a great thing. So we're going to bring Jeff Teichert on. Jeff, welcome to the show. Yeah,
Jeff,
please.
Certainly welcome, Jeff, and we are honored to have you here. I just want to
you got to give the audience has to give them his applause.
There's your applause. I also want to highlight that, Jeff, during the course of your career, you have had the honor of having briefs submitted to the Supreme Court as well. Am I correct in that understanding?
Yeah, in 2008, for example, I had a amicus curiae brief that went to the Supreme Court in the case of District of Columbia versus Heller, which was an important Second Amendment case.
Okay. And I also understand that you have an LLM from George Washington University.
Correct.
In what area?
Well, English and early American legal and constitutional history was the sort of the emphasis of my program.
Fantastic. Because actually, just Nick, for our audience, obviously, Nick, you are an attorney, I'm an attorney, and Jeff is an attorney, but LLMs are highly specialized, and it's beyond, your standard JD degree. So
yeah, that's for the people that decide that 3 years of law school isn't enough, and they got to do that extra year. So it's just the way it is. You're addicted to it. You got to have that extra year of law school, which, by the way, most attorneys won't do. So yes, and right. Jeff has an LLM, right. and from George Washington University. So when you got your LLM, Jeff, were you actually physically located in Washington, D.C., or were you able to do it remotely?
I had a year of coursework on campus, and then most of the writing on my thesis I did elsewhere.
Okay. All right. That's pretty cool.
Okay. So we have here before us today the nomination of Judge Amy Coney Barrett. And I guess for our audience, it begins with, some basic things. So what do we know about her? What can we surmise? A few things that I am aware of, and I'll certainly leave it up to the panel to raise this, is that earlier on in her career, she was a law clerk to former Supreme Court Justice Anthony Scalia. So, Jeff, is that something that's usually important when you are looking at the ways a future nominee sitting on the Supreme Court might, I guess, think about the law?
Well, yes, of course, it's very important. Now, I know Justice Scalia's practice in selecting clerks included that he would deliberately pick one clerk each term that differed with his judicial philosophy. He would pick one that he knew was a left-wing liberal so that he could get challenged by that person. He wanted that person to raise all the other arguments. So you can't just necessarily determine that a Scalia clerk is always going to be a fire-breathing conservative. However, I think Judge Barrett has publicly indicated that her judicial philosophy is similar to Justice Scalia's. So, I think there are indications of what kind of a justice she would be, what sort of judicial philosophy she would espouse. How that's going to come out in individual cases is still going to be anybody's guess. But I think you can imagine that she's going to be something like Justice Scalia in her philosophy anyway.
You know what I find interesting about her as the nominee, Bill and Jeff, is that she did not graduate from Stanford and the Ivies. Okay, now when you think about it, if you go through the Supreme Court justices, they are all Ivy League or Stanford. They don't go to any other schools, which means they're basically go through a certain system that is not that is different than everybody else's, because it's Ivies and Stanford, that's it. And they cut out all the other law schools. I found it very interesting. She went to the University of Notre Dame to get her law degree, which is unusual for a Supreme Court justice. Graduated number one in her class, which is not unusual for a Supreme Court justice, but it shows that we have a very bright person from a different group of people, because it's not an Ivy League school that she went to. So I found that to be pretty interesting.
In some respects, that might suggest that she might bring a different kind of spirit to the role, not unlike some of the previous Supreme Court justices.
Sure.
And like William O. Douglas, say, for example. But I guess what I'm curious about is that, first, Jeff, if we can just kind of start at a broad level, because this is really an important thing, and for the sake of our viewers, the first thing they're going to hear, and they've heard so far, is that this appointment will change or alter the balance of the court to a, quote, conservative court. How can we just explain for some of our viewers who are not attorneys what that kind of translates into when we say it's a conservative court versus, a liberal court or an evenly split court that could, with some swing votes? Jeff?
Yeah, I would love to talk about that. If I could go back 1 second, though, on the point that Nick made earlier, because I think it's an important point. I actually wrote an article for a local media outlet back in 2017 when the appointment of Judge Gorsuch was pending. And the point that Nick made about how, actually, I think there are only 3 law schools represented on the Supreme Court right now, and that would be Harvard, Yale, and Stanford. Justice Ginsburg went to Columbia, and she was the only exception to that, but now, of course, is gone. And Columbia is within that Ivy League group. And one of my concerns and hopes was that they would start to look beyond just those few schools for Supreme Court nominees. I think they don't have a monopoly on legal talent. And historically, there have been great justices from other schools. For example, Robert Jackson, who Chief Justice Roberts clerked for, went to Albany Law School. Chief Justice William Howard Taft went to law school at the University of Cincinnati. Lewis Powell attended Washington and Lee. The great Justice John Marshall Harlan went to Transylvania Law School. Justice Black went to the University of Alabama. So over our history, we've had justices from many different law schools. I think it's become a more elitist kind of body in the last generation or two that just looks to Harvard and Yale and maybe Stanford or Columbia. I'm frankly think it's a breath of fresh air to have somebody appointed from Notre Dame, or, you could look around the country, University of Texas, Michigan, there's any number of great schools that could produce a Supreme Court justice.
And I'm so totally with you on that, Jeff, is because the thing is, this elitism that exists in law is unbelievable, that people don't know how it works. But even like in law professors, there's a school called University of California at Berkeley. It's a pretty good school from what I understand. Claims to be a national school. Okay. And they have professors from the Ivies and Stanford. They have 0 professors from the South, not one. So what happens is, I hate to say it, you get a very elitist bias at this purported liberal school, University of California at Berkeley. I even called them on that. You know what their answer was? Dead silence. And I said, look, the South has 144 million people, and you're telling me there's not one person in the South and one university in the South that you can't appoint to be a professor at your university, University of California at Berkeley? dead silent. So this elitism barrier that exists that is never discussed, Bill,
Okay.
and it does exist on the Supreme Court. I'm glad Jeff brought that out. She'll actually break the glass barrier if she gets in.
Okay. Well, Nick and Jeff, then I'll ask you this then. To the extent that the court, and just picking up on your salient points, do you think that the court in the past, in its judgments, have been detached from the rest of the world because of the lack of diversity of the legal schools from which the Supreme Court has been populated? Do you think that it translated over and makes them kind of aloof and elite in their analysis?
I think it does in a sort of subtle way. I mean, you know, the point you asked about earlier about is this nomination going to tip the balance of the court to a more conservative court? It may not have a direct impact on that in terms of the fact that she went to Notre Dame or that she's a devout Catholic. You know, the fact that she has a originalist judicial philosophy, of course, is going to be a bigger factor when it comes to those things. But I do think that the way different justices write, the way that they think, the way they formulate legal opinions and ideas is going to differ from one school to another. And over time, I think a good cross-pollination of different regions of the country, of different law schools, is a healthy thing for the court. And, you know, I personally kind of enjoyed the fact that Justice Scalia used to go around saying that his best friend on the court was Ruth Bader Ginsburg, who he hardly ever joined in opinions, but they were close personal friends and traveled together and had family activities together. And to me, you know, the fact that you could take a couple like that and find out that they're really good friends, that they, you know, despite the fact that they don't always agree, they could work together. I kind of like that.
Yeah, because I obviously, with the sharing of ideas and then the challenging of each other, makes it a much more rigorous approach to decision making by the Supreme Court. But if I can, Jeff, because you mentioned something that I think that is really important. I mean, and I guess it's two different things. And I'm really thinking about our audience here. I had asked the question about whether or not this tilts the balance of the court and as a conservative court, and what that actually may mean fundamentally for the American people. But I think the point that you raised is far more important. When you mentioned the idea of the originalist philosophy, can you explain to our viewers kind of what that is? And because it's, well, from what we've seen in the news so far, this nominee comes out of that school of thought, and Scalia certainly was part of that school of thought. Could you just kind of explain that to us so that we have a better idea?
Sure. When I ran for the Washington State Court of Appeals, I ran as an originalist. That is my own personal belief. The idea is that we're intended to be a self-governing people. And so what is there that justifies taking a statute and declaring the statute or certain parts of that statute unconstitutional and therefore invalid? What justifies that is that the Constitution was enacted with certain large supermajorities that have taken certain issues out of the realm of politics and placed them beyond ordinary majority rule. And the Supreme Court, as the ultimate arbiter of what the Constitution means, then has a great deal of power to determine if a particular issue or subject has been removed from the political arena and placed beyond that. And so if the Supreme Court is free to go beyond the original meaning of the words, to add new things, to create constitutional protections for new things that weren't intended, the argument goes, and I subscribe to it, that liberty has no refuge, that if the Constitution just means what, 5 justices on the Supreme Court say it means, then it doesn't mean much at all. And and we don't have a security for our liberties. So the idea is that you have to resort to, when you interpret the Constitution, what did those words mean to the people who voted for them at the time? Now, maybe this is getting to be, maybe this is too fine a point, but I'll make it anyway. I spent 2 days with Justice Scalia one time at a course he taught out in Colorado, and he said, people say that, they incorrectly characterize me as a strict constructionist. He said, I'm not a strict constructionist. I don't believe in strict constructions. I don't believe in loose constructions. I believe in reasonable constructions. And I don't believe this was the example he gave, but the idea, I believe, is, all right, the Constitution talks about an army and a navy. It doesn't say anything about an air force. But an army reasonably includes all of the instrumentalities of war. The Air Force is certainly an instrumentality of war. Planes certainly are, and they've been invented since the Constitution was enacted. That's a reasonable extension of what the framers of the document would have included in the Army, and so it's constitutional for the federal government to create an Air Force. A strict constructionist might say, nope, you got to have a constitutional amendment to have planes in the Army. Scalia, he believed that words should be interpreted at the level of generality that they were written. So some provisions of the Constitution are broader and some are narrower by virtue of the way they were drafted. And he would tell you, originalists can have fun too. We won't always agree, but but the goal is to try to capture the original meaning of those words in order to preserve the stability of our liberties and our identity as a self-governing people.
Okay, well, I guess, and Nick, if you have some thoughts, please, I'd like you to chime in as well. But I guess, Jeff, if I could ask this from the other school of thought, and that is to say, under that kind of approach, isn't it's being left up to the individual judge to decide what is a reasonable construct rather than what is a reasonable interpretation? I mean, so doesn't that really just make it subjective, so that it's okay to read a law or a statute to include the unforeseen Air Force, but that it's not okay to read a provision in the Bill of Rights to cover a situation that nobody ever would have thought of, say, for example, the right, Roe versus Wade. Is that a fair criticism of the originalist philosophy, or is that just kind of mistaking it?
Well, of course, I think it's a fair criticism, and judicial interpretation to some degree is inevitably more art than science. A good example of this is there was a case that came before the court involving anonymous speech. And Justice Scalia looked at tradition and he said, traditionally, anonymous speech was not protected. He came up with numerous examples in the founding era and shortly afterward where anonymous speech was not constitutionally protected or the authorities did not protect it. And Justice Clarence Thomas, who is also known to be an originalist, disagreed with Justice Scalia, filed a separate opinion and said, what do you mean anonymous speech is not protected? The Federalist Papers were published anonymously. And that's what Justice Scalia means, I think, when he says originalists can have fun too. We won't always agree on what the original intent was, but I think his idea is, well, we get closer to it by at least deciding that that's the goal, to figure out what the original intent was and whether those principles are being applied faithfully to the original intent. And fundamentally, that's where I come down as well.
Okay. If I could, Jeff and Nick, I guess the inflection point in any of these discussions occurs when clearly we live in a society in America that was never foreseen by the founding fathers. I mean, I wonder, and I know many people have asked us, what they would think if they walked around the streets of Washington today, Washington, D.C., the city, that is, and what they would make of the nation, with automobiles, planes, communications, etc. And that some people, right, maybe reasonably so, believe that the Constitution is a living document and it is designed to take into account a more complex society, and that you really can't reach decisions when you just look it through a viewpoint that tries to establish the original intent at the time that it was written. I mean, what are your thoughts on that, Jeff?
Nick, did you have something?
Yeah. I mean. See, the thing is, I think what a lot of the Supreme Court justices are doing is they don't want to legislate from the bench. In other words, if you're a Supreme Court justice, or if you're a judge, your goal is to judge, not legislate. And I think what the originalists are trying to send a message in a lot of the cases that, look, if you have a problem with our decisions, there are remedies. It's actually in the Constitution. You can amend the Constitution, which we've done, 21 times already? Some prohibition we brought in, then we took it out. So there's the amendment feature. There's also the ability for Congress to actually pass laws in some fashion that may not be overturned in the way that they were written. So there are legislative solutions. The problem that we have, Bill and Jeff, is that the justices like to stay in the realm of being judges and not being legislatures, yet at the same time, they seem to be pushed into a position where they actually are making the law, which I think is very uncomfortable for judges, because that's not your goal or your intent, is to make law. And we're going to see that also in Roe v. Wade, which I think is going to be very interesting, how she's going to handle it, because Justice Barrett goes, well, I'm not here to write the law. Well, does she believe in stare decisis, which means I'm going to follow the law that exists today? If so, she'll actually hold up Roe v. Wade. It'll be a very interesting question to see how she handles it. If she goes, well, I'm going to hold up Roe v. Wade, and here becomes the big but. A new law that is passed, for example, it's illegal unless you have some person who you pass through a committee to get a license for abortion, and then she upholds that, then basically she can erode Roe v. Wade, which is really what you have in justices today at the Supreme Court. And I think that's the reason it's so important. Even though they can't legislate, unfortunately, they actually do.
Yeah, and I guess, either actively or just passively. And that raises another issue. A week after the election, the Republicans are talking about confirming her by having a full floor vote by October 22nd, which means that she would be on the bench. And one of the first cases she would hear is that a week later, after the November 3rd election, is another case before the Supreme Court challenging whether or not Obamacare, or the American Care Act. And because that was decided so narrowly last time, what do you think that might mean for this new case with a new justice? Nick, Jeff?
We'll pass that on to Jeff. Yeah,
I've heard I heard Senator Schumer talking about that just today, and that seems to be the issue he's going to try to hold up the nomination over. I don't have a sense as to where this particular nominee is on the federalism issues and other constitutional matters that might be raised by that case. And so, I don't know what direction that will ultimately go. Senator Schumer, though, seems to be forecasting that that she's not going to be friendly to the Affordable Care Act, one way or another. And I don't know her jurisprudence well enough to tell you whether I can forecast that. But I know that's top of the radar screen for the Democrats. Another issue I think they're going to make a lot of hay out of, and whether this will ultimately prevent Judge Barrett from being seated or not, I don't know. But as you recall, Merrick Garland was appointed by President Obama when there was an election year going on, and the Republicans blocked that, saying it's an election year. The new president should have the opportunity to decide that. They had the votes to block it. The Democrats may or may not be able to block it, to block this nominee. But of course, the charge is hypocrisy. You blocked our nominee when you had the votes to do it, saying it was an election year, and now we've got another election year, and a Supreme Court justice has died, and you're going to go ahead and fill the vacancy.
Yeah.
And frankly, it's a reasonable argument.
It is a reasonable argument.
Hang on, Nick, go ahead.
It's total hypocrisy. Okay, I totally agree with Jeff on this one. It is total hypocrisy. I wish they would just be honest. If they were honest and say, we blocked Merritt because politically he's not who we want, and we're going to accept Barrett because she is who we wanted, then that would be at least honest with the American people. But no, remember, it's politics now.
That's right.
It's totally disingenuous. It's total fraud. It's total hypocrisy. Yet here's my bet. If I was a betting man, she's been nominated. I believe she will be confirmed, and she will be on the bench only because she is competent. There's nothing in her record. I don't think they're going to find anything that makes her anything but a competent jurist. Here's the response if people are upset about this. They go in, they vote, and they make a Democratic Senate, Democratic president, go all Democratic, and they do what FDR was unable to do, expand the court, and then you're back to wherever you want to be. But again, a lot of this is left yet to play out. We're not sure exactly how really she's going to vote on anything. She hadn't had a chance to go at bat, but she really legitimately has the right to go at bat. So if I was sitting on there, I'd vote for her, in spite of the fact I may not agree with a lot of things she does politically, philosophically. It's just the thing is, hey, look, she's the nominee. Yeah, she doesn't have a bad track record. She should have her chance to sit on the bench.
Well, she has declared in news reports that her judicial philosophy is the exact same. Well, I think the quote was, Anthony Scalia's judicial philosophy is mine too.
Right.
And so, at least in some respects, while there are no cases currently pending, we can certainly take a look at that. I guess one of the things that I'm curious about, Jeff, if I may ask you, what were Scalia's views with regard to Roe versus Wade?
Well, that's a complicated question. I think typically when these things are reported in the media, they're reported by reporters that don't really understand the law or judicial philosophy. And so they'll talk about a justice being pro-choice or pro-life. And Justice Scalia would balk at that idea. He would say, I make lots of decisions that I don't like the outcome, but the law compels me to go in a particular direction. And one area where he was very true to that would be criminal justice. He was probably one of the, people don't know this, but he was probably one of the more defendant-friendly justices that the Supreme Court has seen in a long time, because he believed that the Bill of Rights compelled that. And he tended to vote with the liberal wing of the court on those issues a lot, even though he personally was a tough on crime Republican who didn't like the outcome of those decisions. And that's one way in which I've heard Judge Barrett talk about him, as he took the path where the law took him, even if he didn't like it. Now, I wouldn't say he was consistent fundamentally on every issue like that. But his view on Roe v. Wade, I think it's fair to say, was it's not about whether the right to control your reproductive life is important to many women. It clearly is. The important issue for him was the Constitution says nothing about it, and that any construction of the Constitution that we use to get there is fundamentally stretching it beyond the breaking point. and that was where he stood on that. Now, I have heard Judge Barrett talk about Roe v. Wade, and she says, and I don't know if this is tipping her hand or if she's just forecasting what the court would do with or without her on it, that she doesn't think Roe v. Wade will be overturned. She thinks that certain abortion restrictions will be brought before it, and they will analyze it under the Casey framework. That's Planned Parenthood versus Casey,
Right.
Which is kind of the replacement case for Roe v. Wade. And she doesn't believe it'll be overturned wholesale. She thinks that different regulations will be brought in and tested before the Supreme Court. And she may be right. I don't know. And I don't know how far she's willing to go, but she may feel constrained by stare decisis to uphold the central holding of Roe. I don't know.
Okay. Well, if I can, and Nick, I just want to ask you, I mean, isn't this, that's us looking retrospectively. However, having a solid 5 conservative justices, wouldn't that just embolden people to file new cases that go to the fundamentals of Roe v. Wade? So rather than just seeking to erode the provisions of Roe v. Wade, wouldn't the groups that are opposed to the ruling in Roe v. Wade, wouldn't they just come with a brand new straight frontal assault on Roe v. Wade itself, rather than what they've been doing in the past, given that they would have a new Supreme Court? Because oftentimes that's what people do. They run test cases up. And whenever there's a significant change, it could be true in the past, they realized they could only do incremental rulings. But now they may go for the whole kit and caboodle. Nick, what do you think?
Possible, but I don't know. And I guess we're going to find out later on in the hearings whether or not she is inclined to even overturn it because of what Jeff said, stare decisis. I mean, it's kind of the set law. Also, here's another problem, and this is just a problem in American judicial thought anyway. We tend to focus on 1 or 2 issues before the court. Bill, as you know, they deal with hundreds and hundreds of cases, not thousands, but hundreds of legal issues. And we tend to gravitate to 1 or 2 that are very important to us, which the rest of them get thrown in the trash can like they're not important, and they are important. And we've seen them even in the financial sector where they actually made a decision based on inherited IRAs, which I fell out of my chair, but there was a conflict in the circuit. It happened to be the 7th Circuit was one of the conflicts where she comes from, whether or not an inherited IRA could be taken from creditors. Now, you'd think that was not in the Constitution, should not be before the court, but it was in Clark versus Raymaker a constitutional issue, and they said, yes, it can be taken. So if you inherit an IRA and you run into financial difficulties, you can lose that. Now, to me, it's very important that all of my clients know about it because a lot of them inherit IRAs and they don't realize that they could lose it all in just a bankruptcy proceeding. These are day-to-day nuts and bolts that the court deals with. And on top of it, she brings another interesting dynamic. She's 48 years old. She's young. And she grew up in a whole different era with the internet, with the computers. These other senior judges, as much as I like them, they didn't grow up with that. So we're going to see a new, younger perspective in the legal area that we haven't seen before. But I think that these dynamics are not really addressed. We like to focus in on Roe versus Wade or whatever the hot topic is before the court, and not what I call the nuts and bolts. It's just like governance. If you govern, a lot of what you're doing is you're doing boring work. You're building bridges. You're making sure the trains run on time. Right. You do a lot of boring work, but that's not what everybody focuses on. They're going to focus on the exciting, the adversarial issue, the one that gets people's blood up, which would be something like Roe versus Wade.
Well, and I mean, you're right about that, Nick. And Jeff, I'm going to come to you in just a second, but I just, I have an observation on that point, and that is simply that the reason why we're focusing on these issues is because they are so important. You're right. The running the trains on time is not sexy. Doesn't get you a lot of likes on Facebook or anything else, and you're not going to be doing a TikTok video about it either. However, the hot button issues are the ones, and in this election, which is by anybody's account completely unprecedented, with seemingly the weight of the world on the American voter. These are the issues that get people interested and excited, which is why we are obviously talking about a Supreme Court justice nominee. Now, but Jeff, though, isn't Nick essentially right that not only are we seeing, and Nick, you're right for two reasons. We're seeing a generational change, and that may be the precursor to a generational view of approach towards legal philosophy. And the other point that Nick made is that her age, 48, she could, if she just serves, she could be on the bench for about 30 or 40 years, depending, which would be a seismic, substantial impact on the way we look at the Constitution. Am I right about that, Jeff, or are we? What are your thoughts?
Oh, absolutely. I think you're right about that. I mean, Chief Justice Roberts went on at age 50. Clarence Thomas actually joined the court at age 40. And I remember him saying, I'm going to be on the Supreme Court for 40 years. And he's in the 30s now. And he's only 75. I mean, he could serve another 10 or 15 years potentially. Yeah, I mean, and over time, a justice writes a lot of opinions. I mean, they decide 90 or so cases a year, and each of the justices, gets 10 of those opinions. If you think about how many opinions a justice is going to write over 30 or 40 years, it's a lot. I also agree with the point Nick made. If I could address Roe v. Wade again really quickly, though.
Okay.
There was a point that you made about it earlier, that maybe they'll bring up a test case, and that could happen. Just from as an attorney, if I was going to advise them, the pro-life movement, and they're probably not going to take any advice from me. But if I was going to give them advice, I would say, look at what Thurgood Marshall did middle of the last century when he was working to overturn Plessy versus Ferguson, the separate but equal decision. He didn't just bring Brown versus Board of Education and overturn Plessy wholesale. They brought a series of small incremental cases until they knew that they, or were pretty sure that they could get 9 votes to overturn, because they wanted a stable precedent. And nobody has questioned Brown versus Board of Education since then. It's been one of the most stable precedents the court has ever decided. I think the pro-life movement got a little too anxious after they had a few justices appointed and thought, well, we're going to be able to overturn Roe. And they brought the Casey case, Planned Parenthood versus Casey. And, they had Justice Anthony Kennedy, Justice O'Connor, and I think the other one was Souter, if I remember right. The 3 Republican appointed justices anyway that joined the plurality opinion in that case. And the first line was, liberty has no refuge in a jurisprudence of doubt. And they upheld the central holding of Roe. And I think they would be far better off to have fewer delusions of grandeur and bring the cases incrementally and test the waters. Because if you go back and you affirm Roe again, then you're 20 years behind. You've backslid 20 years again. So I can understand the temptation to think, oh, we finally got the majority we wanted. Let's take it out for a spin and see what we can do. I think that's probably a mistake. And the court rarely just takes a precedent that's been in place for a very long time and dumps it.
Mm-hmm. Okay.
So
if I can pivot, because I want to get back to a point that Nick raised, and I want to make sure that we give it due justice, and that is there are a number of cases that are coming up that are going to be dealing with the tech industry and antitrust laws, and that is certainly going to have a huge impact on business. And it's one of those other areas where Supreme Court justices really do make an impact and change society, either actively or passively. But what was Scalia's judicial philosophy when it came to the government and business regulations or those general types of financial matters, Jeff and Nick?
Well, one of the things I can say about Scalia on the antitrust issue, and that I can say about antitrust in general, is it is, boy, I hate to use this term, it is the most constitutional statute there is. And I don't mean that literally. What I mean is that the Constitution is in many ways phrased in broad general language, and the antitrust statutes are too. And so they have relied a lot on judicial interpretation to decide where they're going. And that's one area where I know Scalia was somewhat active. What Judge Barrett will do on that, I think, is anybody's guess. She hasn't been on the bench long enough to really know. I mean, there are areas where I think Justice Scalia was not a consistent originalist. When it comes to antitrust and a lot of other legislative issues, I would take issue with the idea that he was an originalist. I mean, he was famous for saying legislative history is dead. And I think maybe as a practical matter, Scalia was dubious about looking at statements that were placed in the congressional record after something had already passed, or you know, that big long statements that nobody ever read and considered were made part of the record. And so he didn't want to use those things. But when it comes to interpreting the Constitution, he reads all kinds of background information. And so my view is I didn't ever like the idea that he thought legislative history was dead. And I remember briefing for the Supreme Court in two different cases. And we would talk about, okay, which justice are we going to write this paragraph for? And we would talk about legislative history, and people would say, yeah, Scalia won't read that at all. And we got to have his vote. And I think the reason is what I said, but you know, he would never let that wash if it had to do with the Constitution. Then he would be, well, no, you just got to go to the original material and be discriminating. And I would say, do the same thing with legislative history, you know, read it, but be discriminating. You know, the committee report's probably a lot more authoritative than the statement of one individual congressman, for example. Anyway, when it came to statutes, I think he was a textualist. I don't think he was an originalist.
Right. Yeah, and we're going to see a lot of new cases before the court, like the TikTok. You just briefly mentioned them, Bill. You know, TikTok, there was an executive order basically saying it threatens national security. And for me, looking at corporations, and I don't work in the constitutional area, I work in corporate world, okay, with businesses. I look at this problem that a president of the United States can order a company to change the composition of the ownership based on potential national security threats. Well, I had a problem with that one because, as you know, IBM TV, we broadcast to 122 countries,
Right.
and I have to get along with 122 countries. And the last thing we want, because we have a China show on IBM TV, is to have the Chinese people mad at us because TikTok, who we have nothing to do with, is being forced to divest themselves away from having Chinese ownership. Now, a federal judge just put a stop to that right now. But see, that is an issue because it deals with executive power that can go all the way, percolate all the way to the United States Supreme Court. And see, this is part of the nuts and bolts. There's not a lot of emotion going back and forth unless you're involved in the corporate and international area. And then all of a sudden, I'm sitting there going like, wait a minute, you know, we have, since a lot of our audience comes from India, we have an Indian representative on our board that all of a sudden they go, you can't have an Indian on, a person who's not a United States, because why? Well, they may get national security interests are threatened. Why? Right. Because we're broadcasting around the world. So you see, it has implications to what we do, and I think the court has to be aware of what I call the retaliatory acts of other countries that could adversely affect our interests, and they're going to end up ruling on it. How she'll rule on these issues, I don't know, because and this happens with all the jurists that come from the elitist and frankly non-elitist schools in the United States, they don't have much international education. They don't go abroad, they don't live abroad, and they don't get education from other countries. And so we tend to work in a very isolated vacuum here in the United States, and that has always bothered me, as you know, Bill. In other words, everything's U.S. And wait a minute, Malaysia has how many COVID deaths? 128 with 32 million people.
That's right.
You know, but we don't even recognize Malaysia as a country. So why do we care that they're very successful in controlling controlling COVID-19? And see what happens is that the problem that I see, which I think she'll be more likely to be more international than the rest of the group, is that we have 300 million people. The people that are listening to us in India have 1.3 billion people. Yeah. And we don't recognize that. Our Chinese, 1.3 billion people. Yeah, Malaysia, only 32 million. And frankly, we broadcast in South Africa, another 34 million. It's like we don't recognize these other countries. And ultimately, because of the internet, we're going to see a seismic shift in dealing with international issues. We even saw that on Economics Monday today. So one of our representatives go, "Hey, you're dealing with international tax law. That's way beyond what I can handle." And we're going to see that over and over again.
That's right.
Hey,
Jeff.
If I could also speak to a similar subject to what Nick just talked about, because I really appreciated what he had to say on these business issues and the exercise of executive power. Another area where I found Scalia to be kind of a walking contradiction was, it's very clear in Article 1 of the Constitution that all legislative power is vested in a Senate and House of Representatives, and he was a huge advocate of administrative law. And he wrote a very famous article where he started out, administrative law is not for sissies, and then he talked about administrative law and thought that it was great. And if I could read his mind, I think, well, maybe he believes that the president's elected, and so he's a better arbiter of the meaning of statutes than the courts are. I don't know, but I've always been puzzled, because more than any other justice in recent memory, he's probably responsible for the growth of the administrative state. And I think, I honestly think the biggest threat to liberty in America today is not antipathy to religious freedom or anything else. It's not abortion. It's not, go down the list of things. It is really the transfer of legislative power to the executive branch, not just through presidential executive orders, but through rulemaking.
Right.
You look at the U.S. Code annotated, or the U.S. Code, it'll take 2 shelves in the library. Look at the Code of Federal Regulations. It's a whole huge wall. And the amount of legislation that's really being written by unelected bureaucrats and imposed that sometimes radically changes what the law means is vast. And it's a huge transfer of power. Now, as a legal historian, which I am, I look at the fights they had in England, for example, in the mid-17th century, when King Charles was ruling by decree, and Parliament was saying, you can't do that. You can't just impose these creative taxes and things like that. Well, for that matter, what was the Declaration of Independence about? It was about taxation without representation, and the king dissolving legislative assemblies and refusing to call new ones. It was about the executive supplanting the people's elected representatives. And I think it's a huge problem that nobody's talking about.
I agree.
And all those issues, like Nick talked about, when it comes to business, trade, you name it, and frankly, you've seen it during the COVID-19 thing at the state level. Governors are just ruling by decree. They're imposing restrictions, and they're telling people to stay in their houses and all kinds of stuff without even calling the legislature to ask permission. And I think, why are we putting up with this?
This part I would concur with Jeff on, and because I've seen this, it's executive power, and my thoughts of the executive is supposed to execute the decisions made by Congress or made by their own legislative branch, not to create the law and execute, but we have seen a growth in what Jeff is saying, executive power, almost kingdom-like. And it goes with our friend the Donald, his predecessor. It'll go with the next one, and on issues that I go, wait a minute, you're never consulting Congress. As a matter of fact, Congress doesn't look like they're doing anything. In other words, why do we even bother to have Congress? Everything's executive power today, and sooner or later that's going to get reined in. I agree with Jeff.
Okay, well, Nick, do you think that on that last point, do you think that it rises to the level where it can best be termed an abdication by Congress of their constitutional mandate to, write the laws and control the government? Because it seems to me that that's kind of where we're headed, and I think that your salient point at the beginning of the show is that if people don't like it, they can,
right,
change the parties.
But you go to the abdication. It even deals with this COVID-19 crisis and passing enough money to take care of people. Trump did an executive decision, and Congress sat around and did nothing.
Right.
Okay, and so the real problem is they do tend to add. They tend to be a do-nothing Congress, and when that happens, then of course you have the growth of the executive branch. It's not right, because that's not really intention of the way our government. I think Scalia would agree. He would go, look, you guys are the legislature. You need to get your rear in gear and pass the law, and then the executive branch executes the law. But that's not what's happening today. Not just as Jeff pointed out correctly, not just in the heads of power in Washington, D.C., but frankly, all the states are the same way. And sooner or later, we need to go back to the legislatures and the Congress people. They need to get off their rear and pass laws.
Yeah, I guess, sorry, go ahead, Jeff.
Well, I was just going to say one of the biggest problem cases in terms of this is Chevron. And that came up during Gorsuch's nomination hearings, because he had questioned whether it might be time for the Supreme Court to revisit Chevron deference to executive authority. And I've thought that for years. I litigated against the federal government for the first few years of my career. And you were always playing against a stacked deck, because the agency was given preference for its own interpretations of the statute. Right. They could prefer the opinions of their own experts.
Right.
Then if they made a decision that went against you, you had to prove it was arbitrary and capricious to overturn the judicial forum. And there's no due process in that. It was completely playing against a stacked deck. And I was frankly glad to hear Judge Gorsuch say that he had questions about whether that was right.
Yeah.
And, what this particular nominee would do, I'll be interested to see if they question her on it in the hearings. But that's one area where I think Scalia really lost his way, and I think maybe he spent too much time in the executive branch. The president really trusted, and who I really, but still.
And we see this in our industry all the time, Bill, is that the decisions and the law is being drafted and implemented by bureaucrats. And we are forced to follow them, whether or not we like it or not. And a lot of our clients go, well, our choice is to follow or fight, and fight is very expensive. So we end up tend to follow what they're saying and what they're doing. And some of it is arbitrary and capricious. We've had a couple of them in my area where they just, it wasn't by legislative fiat, it wasn't by executive power, it was a bureaucrat wrote a rule, stuck it in there, and we have everybody following it, and I'm sitting there going like, how could they do this? They're not congressmen, they're not senators, they're not an executive branch. They just throw a rule out there, and some of them are significant, and we're kind of stuck with the rule. Our other choice is to go fight them, as like what Jeff said, and then we end up in a battle which we're disadvantageous. We'll have to see how, and that affects everybody's lives, even though we don't like to admit that. And I can go on some details of it because I got involved in it, but man, it's a problem. Yeah, it's a problem.
And so I guess what I hear is that if and when, because I believe that she'll be confirmed as well, we are in for interesting times with the Supreme Court on a whole range of issues, because to the extent that they rein in executive executive orders, things of that nature, that's really going to upset, at least, or change the way we're looking at the world and how we operate.
Mhm.
I guess it's interesting. Now, do you guys have any thoughts on this nominee replacing Judge Ginsburg?
Well, I think they're different.
No,
They sit on different sides of the political stack, I would say.
Because
South Africa, I would expect her to be very different too.
Yeah.
Okay, because I just kind of it's just curious for me that Clarence Thomas was nominated to replace Thurgood Marshall. It was, and it seems to me that this is that exact kind of switch, Nick.
Yeah, but also you don't know how they turn out. A lot of people said, "Oh, Roberts is going to be right. You know, he's going to be wing to right." And I see Roberts doing some very interesting, and frankly, I follow him a lot, and I kind of like him on the court because he seems to be a very balanced mind. And so Chief Justice Roberts is now one of my favorite justices. And the thing is, she may become one of our favorite justices. We always look at, oh, she's going to be too far right, she's going to be this and that, but you don't know until she gets on there and starts writing opinions and being a part of it. And William Douglas, remember him?
Yes,
Yeah, William Douglas, that radical right-wing William Douglas. Well, he turned out not to be so radical and right-wing. So you never know once they get on the court exactly what they're going to do. But is she qualified? I mean, if you're a senator right now, is she qualified? The answer is yes. She should be approved. The answer is yes.
Yep.
Was the Senate or certain members, not all, because not all of them agree with this, and not all of them were there when this took place.
That's right.
Did they railroad Obama's nominee? And are they hypocrites? The answer is yes. There's absolutely no question. And this is where Jeff and I agree. They're hypocrites. If they weren't, here's the right thing to do. McConnell gets up there and say, look, we had this position before. We're going to take it again. We're going to wait till the next president elects. That would be the right thing to do. But that's not the political thing to do. And in politics, just because the right thing doesn't make the right choice. In other words, I've never seen the backbones that strong where somebody's going to actually go against the political will to make a right decision. So they're called politicians. So yes, they're hypocrites, but yes, she's going to get nominated. And frankly, it's not her fault that Garland isn't sitting on the court. She had nothing to do with it.
Yeah, that is unfortunate because everything else has become so politicized. But that's the nature of the beast that we have right now. And so it just creates doubts, and it's unfortunate for her because you're absolutely correct that by all accounts she absolutely is qualified, but the politicians have made a mess of the entire process.
Right, so, and I'm sure it'll be a very interesting. Let's put it this way. Circus up in your city, Washington, D.C., where you live, Bill. Jeff and I do not live in Washington, D.C., but I'm certainly the circus will be coming to town when she is being reviewed by the senators, and maybe you should go in and stop in and say hello. But I don't know if you can because of COVID-19. But we're going to have this on every week, and we're going to be discussing her nominee. I think that's really going to be a very important legal future. In other words, the legal decisions. And with that, we're almost at the hour. So we should thank Jeff Teichert from coming here on the Lawyer's Den. He has a great following, and he knows this stuff, which is not me, because like I said, I only follow the business stuff. And of course, Bill, thank you for putting this on. And everybody, welcome to American Politics, the Lawyer's Den.